All right, good afternoon, and thank you so much for joining us today for Avoiding Risk and Litigation in the COVID-19 Work Environment. I'm Jackie Petroselli, the Marketing Specialist at MP. For those of you joining us on a webinar for the first time, MP is a full-service human capital management services company. We provide a single solution and support for HR, payroll, benefits administration, time and attendance, and compliance. We're joined today by Tawney Alvarez from Verrill. Verrill is a full-service law firm with more than 130 attorneys and 7 offices throughout the Northeast. The firm's attorneys provide award-winning client service to businesses and individuals across the country and around the globe in a variety of areas and industries, including construction, energy, food and beverage, healthcare, higher education, manufacturing, technology, and telecommunications, among others. For more information about the firm and its values, you can visit their website at www.verrill-law.com. And now to introduce our presenters. First up, we have Paul Carelis, who is the VP of HR and Client Services at MP. He has over a decade of experience in the HR consulting space, working with businesses of all sizes and all industries. Paul and his team of certified HR professionals at MassPay assist clients with compliance, training, and full circle HR guidance and support. Tawney Alvarez centers her practice on the understanding that the employment landscape is ever changing, from medical marijuana's effect on drug testing to the effect of social networking in the workplace and mobile devices' effect on wage and hour issues. In this evolving landscape, she recognizes that for companies to remain profitable and successful, they must be proactive, as opposed to reactive to these employment issues. Tawney's experience clerking for judges across the country at the trial court level and the Third Circuit Court of Appeals has provided her with valuable insight on the ins and outs of litigation. She's the recipient of the 2008 Adolf Homburger Humanitarian Award and the editor of the Verrill Employment and Labor blog, Taking Care of HR Business. And with that, I will hand the mic off to Paul.
Awesome. Thank you, Jackie. And hello, Tawney. Great to speak with you again. It's always a pleasure chatting HR and employment law with you.
Absolutely, Paul. Thank you so much for doing this with me.
Yeah, no, definitely. So looking forward to jumping right in and kind of tackling. So this has been a really unique situation. I mean, obviously, employers that have been around for a while have gone through economic downturns and challenges and things like that. For me, the real difference is how sudden this was. One day it was business as usual, and the next day it was mandated closures and just a real shock to the system of business owners across the country and really across the world. So, in what I'm seeing and working with clients, and I'm sure you as well, is just, so much focus has gone on to keeping the business alive and taking care of the employees that it's very easy to put some of the laws and regulations in the back of our heads, but I suspect that those will soon be upon us in no time.
I absolutely agree. And I think it is important for us to note that today we are going to be focusing on kind of the reopening aspect of things and laws and regulations and compliance concerns as to that. At the same time, I think it's important that everyone recognize that while we're not focusing specifically on the emotional well-being of both our clients and on our staff, that also needs to play a role in all the decisions that we're making, understanding that everyone is experiencing the last few months in a different way, whether or not it's with children at home, whether it's with aging parents, whether it's higher concerns regarding immune issues. So even though we may not be focusing on all those aspects, understanding that everyone's world has changed in the last few months, I think is so important.
Yeah, no, that's an outstanding point. Definitely should keep that in context as we discuss the various points today. So if you're ready, I guess we'll jump right in and let's talk about FFCRA. So this is one of the original kind of pieces of legislation that was passed in the early phases of stimulus and response to the COVID-19 outbreak. So why don't you share a little bit about FFCRA and kind of how it can help employers and employees and how it can potentially be a liability or exposure?
Absolutely. So from a federal standpoint, we have the Families First Coronavirus Response Act, or the FFCRA. And this is a law that it will be in effect for a short period of time. So it went into effect on April 1st of this year, and it's only applicable through December 31st of 2020. The statute itself has two distinct kind of areas in which paid leave is provided to employees. And it sets forth different qualifications for employers as to whether or not they will be mandated to provide paid leave to employees. So the first thing that I recommend to all employers, whether or not you have been open throughout the course of the pandemic because you've been deemed an essential business, or you've been closed, or you've had employees working remotely, is to understand and recognize that there are posting requirements under the law. So make sure that you have shared the Federal Department of Labor poster concerning employees' rights and responsibilities to paid sick leave and expanded family and medical leave time. So that is the first step. So if you still have employees who are working remotely, make sure that they have had access to that poster. If you have people who haven't been working but are returning to work and are going to be returning remotely, make sure they get a copy of it. And then people who are returning to office space, retail environments, just your on-site work environment, make sure that's posted somewhere where employees can see and have access to it. Recognize and understand the paid leave that is set forth in the Families First Coronavirus Response Act, and determine, usually with your operational staff, whether or not you are a qualifying business or employer under the statute. So if you have under 500 employees, you likely will be found to qualify or be covered under the FFCRA. But there are exemptions for healthcare providers as well as businesses that have under 50 employees. But if you have under 50 employees, to take advantage of that exemption, there's going to be very specific requirements that you are going to need to meet. So you're going to want to go onto the Department of Labor's website, take a look at those requirements, and determine whether or not FFCRA is something that is applicable to you. Recognize and understand that one of the benefits of the FFCRA is not just that employees will be receiving paid leave, but also that you're going to have a tax advantage associated with that leave. So you're going to want to be working hand in hand with your finance or accounting department, as well as your operational team. Now, there are 6 specific ways or reasons why an individual may qualify for leave under the Families First Coronavirus Response Act. And it includes people who are subject to state, federal, or local quarantine or isolation orders. They've been advised by a healthcare provider to self-quarantine. They're experiencing COVID-19 symptoms. They're caring for an individual who either has COVID-19, who's been advised to stay home by a healthcare professional or is subject to quarantine, or they are unable to work because they are caring for a child whose school or place of care has been closed. Now, individuals or organizations that have maintained operations or have been essential businesses throughout the pandemic have likely been dealing with this throughout the course of its institution, so from April 1st to now. But for new operational businesses that are just reopening or bringing on new staff, be mindful that this is also something that should be at top of mind. You should also be mindful that there are caps for how much can be paid out to individuals if they are taking leave for any of these qualifying reasons. Now, for individuals who are experiencing symptoms or have been advised by healthcare professionals to stay home or have COVID-19 symptoms, or are caring for another individual, we are allowed or permitted to provide 2 weeks of paid leave for that time. But you're going to want to have documentation in the file that supports kind of one of these reasons for leave. and they're going to be entitled to 100% of their pay, up to $511 a day. If an individual needs leave to care for a child because the school or place of care has closed, that individual is going to be entitled to up to 12 weeks of leave, and it's up to $200 per day and $12,000 total. Now, you need to be mindful of how that's going to play a role with any of your currently used policies regarding paid leave. And you also want to make sure that if you are a business that previously has not used any form of FMLA, that you understand the paperwork and documents that you're going to have to provide in order to keep track of FMLA leave that's been taken. And we're going to talk about that a little later in the program. But that, in a really quick nutshell, which is tough, are things that we need to be mindful of from the Families First Coronavirus Response Act, at least from an initial standpoint when we reopen.
Yeah, no, I think that's an outstanding recap. Just kind of cruising some of the questions live here a little bit. One thing to point out that I think was a misconception, especially for businesses that have been open throughout, that this really isn't meant as a leave program if you're non-operational. So this is for instances where there is work available. It's just that because of the employee's health or their need to care for a sick loved one or their child whose daycare or school has been closed, that they need to take the leave. It's not kind of in place of unemployment when they're otherwise laid off or on furlough or something like that. And in terms of best practices, as Tawney said, we'll be talking more about FMLA and things of other types of leaves that have been around and continue to be around. But much like those, I think from an HR best practices standpoint, one thing to do is just make sure that your managers and supervisors are well trained and how to on the law, what the rights of it are, so that as they're working with your employees, they're recognizing potential situations where this might apply, so that you don't take any type of adverse action or fail to have this available when it should be utilized.
And just to answer a couple of the other questions that I see, it's 50 employees. It's the full-time equivalent doesn't come into play here. You can send the poster via email if individuals are working remotely, or you could have it posted on any internal intranet or website, as long as people would have access to those. The posters don't need to be posted if you have over 500 employees, but if you have under 500 employees, but you are planning on taking one of the exemptions, such as the healthcare provider exemption or the under 50 exemption, you would still need to post it. And then my recommendation has been that you explain why the leave won't be available in a posting kind of near that poster. So another question, we have over 500 employees across multiple states. The FFCRA does not apply to us, correct? Unfortunately, this is that lawyer answer. It depends. It depends upon how your entity is set up and whether or not an argument could be made that there is an integrated enterprise. But if you have over 500 employees, one entity, then it wouldn't apply to you as an organization.
Thank you.
If the employee has already used FMLA over the course of the last year, depending on how you qualify that year, whether it's rolling or calendar, individual will not be entitled to any additional leave as a result of a child care provider or a school being closed. So if they've already used all 12 weeks of leave, then there's no additional leave.
Great. All right, so let's talk a little bit about reopening. Obviously, a lot of potential pitfalls there and a lot of considerations that need to take place as you reopen the doors to either to your employees and or the public.
So this is so important, and this is a really tough time because employers, so individuals in HR, operations, and management are being asked to keep track of so many different cites regulations, rules, and responsibilities that it can very quickly become overwhelming. What you need is you need to have an individual who's put in charge of keeping track of changes in operational requirements, prerequisites, and general precautions or orders. So while normally we would say kind of look at the federal guidance and look at state guidance, currently we see regulations that are being put in place from a municipal or a city standpoint. So determine whether or not your business falls within any operational restrictions from a local level. Then look at the state level restrictions on your reopening. And we're not seeing federal regulations as to a reopening standpoint, but we are seeing guidance about what to do when you reopen. So using the CDC guidance and going to the CDC website on a daily basis is important, because as we obtain more information regarding COVID-19, the way that it is transmitted and symptoms, we want to make sure that we are updating our policies and practices on a daily basis as we receive more information. Now, from a liability and risk standpoint, what I'm hearing from a lot of clients is that different state regulations are overly onerous, or do I have to do these things? The answer is, again, unfortunately, it depends on the language that is being used from the state in which you're operating. Many of the reopening plans or documents are called quote unquote guidelines. So a guideline would be like, okay, you can do it, you don't have to. But then within the documents, they say that employers must take a certain action. The use of that word must is such that there is a strong likelihood that if there is an audit of practices from any state administrative agency, that failure to follow those prerequisites will result in some type of fines or loss of licenses. Another thing to be mindful of is from a risk maintenance standpoint as to liability from potential customers or employees who contract COVID-19 or allege that they've contracted it through your operation. Being able to point to the fact that you have followed all of the guidelines that are set forth for your operation will go a long way in showing that you have done everything in your power to mitigate the risk of transmission at your establishment. So one of the questions that we've received already is this question of if we have access to testing, can we require that our staff be tested? You could require that your staff be tested, but I would want you to perform a full analysis as to why you would do that. Are you going to do testing for all employees every day? If you're not going to do it every single day, what is the benefit? Because if you do it one day and someone comes in the next day and they have the symptoms, has that helped to decrease transmission? What other steps are you taking kind of during the course of the process? Right now, we're seeing that the tests, there's at least 70 tests out on the market, is my understanding, and that we are seeing false negatives in 20 to 50% of the tests that are out there. So how reliable are the tests that you are using? So it may be that you implement some form of COVID-19 testing, making sure that you are mindful of information concerning the employee's privacy, health information, medical information, all of those things. But you're also asking employees to complete another form or checklist when they come in, certifying that they don't have any symptoms, certifying they haven't traveled to a high-risk country or location since they last were at work, certifying that they haven't knowingly come in contact with an individual who has COVID-19. All of those different certifications. So it's a multifaceted approach to how we reopen, but all of it should be taking into account the regulations or standards that are set forth for our industry at a state, local level, and using CDC guidance.
Yeah, no, those are all great points. What are your thoughts on, and a question that's come up often is waivers. So waivers for employees, waivers for customers, things like that. Is there any value or maybe potential risk in trying to utilize a waiver of some sort?
So I'm going to take it into two different categories: waivers for employees and then waivers for customers or clients. So a waiver for employees is likely going to be found to be in violation of your state workers' compensation act, depending on the language in which you use. What I have recommended to some clients is a use of an acknowledgement form that very specifically states that it's not a waiver of any workers' compensation rights, but instead sets forth an acknowledgement by both the employer and the employee as to how COVID-19 spreads, our expectations that the individual not arrive at work or attempt to work if they're showing any symptoms, the steps that we're taking as an organization to maintain the health and well-being of our employees, including things such as social distancing, increased hand washing, sanitization practices and standards, personal protective equipment that we're offering. So it's more of a general acknowledgement. As to waivers for clients or customers, I have not seen an effective way in which it will operate generally. And one of the reasons that a lot of the litigators that I work with are recommending that one isn't instituted is because the standard of care for proving that an individual contracted COVID-19 at your location will be very difficult. Does that mean that there won't be lawsuits? Absolutely not. We know that people will sue for anything, and we will see an increase in the number of lawsuits as a result of COVID-19, but I don't think that they will be successful lawsuits because of how difficult it's going to be to show spread. Now, one of the things that we're getting a lot of questions about is people walking into businesses that have some type of mask or facial covering requirement that state that in order to enter the location, you must be wearing some type of face mask. And we've been seeing the creation of these posters that state that it's a violation of their rights to be required to wear a face mask, and they will sue you for violation of the Americans with Disabilities Act for public accommodation discrimination. We've reached out to some state fair employment practices agencies, and it's their position or belief that using the Americans with Disabilities Act and the EEOC's direct threat analysis, that you could limit these individuals from arriving or using your facilities or your public accommodation, and that it's not a reasonable accommodation to permit people to use your accommodation or your services without wearing facial masks. So that is something that we are seeing some of, opposite from like the waiver standpoint, but more of a refusal to follow precautions.
Yeah, no, that's great. That's excellent information. News to me. All right. So, for those of you who have been on MP webinars over the last couple of months, you've heard a lot about the CARES Act and the Paycheck Protection Program. From an HR and best practices and financial standpoint, I'd love if you could, Tawney, to shed a little light in terms of legal ramifications around all of this.
Yeah, so what we're hearing a lot of is misconceptions by employees about what the PPP does or is. So we have a lot of employees who are coming into work saying, I'm entitled to paid time off, or I'm entitled to not come into work but still get paid at 100% because you have a PPP loan. There's this misconception that employees receive some type of direct benefit or right if their employer took a PPP loan. Instead, the PPP process, as everyone or most people on the call know, had very specific prerequisites that were set forth in order for the loan itself to be forgiven. An employer may choose not to meet any of those requirements and not have the loan forgiven, but no specific rights are set forth for employees in the loan. But what's important to understand is that employees can bring what's called a qui tam lawsuit. And that's important because in making or your certification or your application to get a PPP loan, you certified that the loan was necessary to support ongoing operations. So if an employee believes that your business wasn't eligible for a PPP loan, or the business didn't spend the PPP money as it's set forth on filing. So let's say that it made a filing saying that it used the money for one thing, but it really used it for something else. Or a certification that the loan was not necessary to support the ongoing operation of the applicant, or that the small business had recourse to other monies. So that individual would become a whistleblower. And if they believe that any of these violations have occurred, they can bring what's called a False Claims Act, saying that the employer falsely obtained money through fraud from the United States government. And they then become a whistleblower, and there's an investigation. And there's something called False Claims Act or qui tam retaliation that you should just be mindful of. So that is one way that we expect that if you are, I don't want to say committing fraud, but if you are haphazardly using your PPP money, or you're making certifications and not sure that what you're certifying is fact, be mindful that there are these avenues for redress in which employees can become whistleblowers to the federal government Small Business Administration under the False Claims Act.
Yep, no, that's very valuable information. And the PPP is ever changing. For those of you who may have missed it, since our last webinar, there was a further update to the interim final rules last Friday night. I think it arrived somewhere around 10 p.m., but some good news in terms of including bonuses as forgivable amounts. But you know, somewhat related to this perhaps is that in addition to sending a formal documented job offer letter in recalling someone and getting that rejected, in order to remove someone from your FTE calculation and comparison, aside from the written offer and the documentation, they are now saying that within 30 days of that, you do also need to report that individual to their respective state unemployment department. So kind of as Tawney said at the top, that's going to create perhaps a moral dilemma for a lot of employers who are hoping to perhaps avoid that step and still be able to remove certain individuals from their FTE calculation. So things could get tricky with that for sure. For those of you who are hungry for more PPP information, I can share that next week's webinar will be PPP Mythbusters. So all that and more coming this time next week. All right, so I know we've kind of started down this road a little bit, especially with the ADA and masks and face coverings and all of that. If you could, Tawney, maybe share your thoughts from a legal perspective on some of these discrimination statutes and how businesses could be exposed.
Absolutely. So under the Americans with Disabilities Act and many state fair employment practices statutes that had protections for individuals with physical or mental disabilities, it's important to note that when the employee or garnered information regarding a disability, they have an obligation to begin what's known as an interactive dialogue concerning a possible reasonable accommodation. For employers who have been operational throughout the course of the pandemic, in most cases, they've moved some people to a remote work environment, right? Now, previously, when we've dealt with ADA issues, what we do is we look at the employee's job duties and responsibilities, and we determine whether or not any accommodation would involve would assist the individual in being able to perform the essential functions of his or her position. In a lot of situations, employees would ask to remote work or work from home. Usually this was as a result of anxiety, depression, difficulties from a physical ailment standpoint of being close to other people. And oftentimes we would say that essential function of the position was to be physically present in the work environment. Because of COVID-19, we've moved a lot of people to remote work because we have to. The question becomes then, is physical presence in the environment an essential function of the position? You're going to need to go through each of your job descriptions and determine whether or not this is now a job that can be performed remotely. Because as we are bringing people back to work, we are going to hear a number of people who say any of the following things. I'm a high-risk individual, and my doctor has recommended that I not return to the work environment despite all the precautions that are put in place, right? Can I continue to work from home? You're going to need to determine whether or not continued work from home is a reasonable accommodation under state or federal law. There could be people who are simply saying my anxiety is such that I don't want to come into work. Recognize that when people talk about anxiety, it likely could be a disability at this point in time that restricts their ability or puts them into a protected class. Additionally, things like asthma that previously weren't a problem or weren't interfering with the ability to perform the essential functions now likely could be a disability that needs to be taken into account. And then, so that's kind of generally things to be mindful of with the ADA and state law, and then age discrimination. So as you're bringing people back to work, you're going to want to set up the process in which you're calling people back to work if you don't need everyone at the same time, and make sure that in that process, you're not taking into account people's age. So I've had some clients who have said to me, well, we're not calling this person back because they are in a high risk category because they're over the age of 60. It's not our right to determine whether or not they're high risk just because of their age. That actually would be considered a form of age discrimination. If the employee says, I don't feel comfortable returning to work, and my doctor has stated because of my age, they recommend I don't, that's when we have that reasonable accommodation dialogue. But we don't simply say, if you're over the age of 60, you can't return to work because we don't want, you're high risk and we don't want to take that risk.
No, great point. So, I mean, I think especially with the ADA, hopefully for clients who've kind of been sleeping on their documentation, their job descriptions, I think pretty much every webinar I've participated in, or anyone who's used to working with me will know how I always shoehorn job descriptions into our recommendations. But this is yet another example of where they're just so crucial and so important. And you know, to speak to your point, Tawney, that it's not necessarily set it and forget it type thing. You need to constantly be checking them and reviewing them for accuracy and how realistic they are to the work that's actually being done or expected to be done.
Exactly. And employees who return to work and refuse to follow some of the precautions. So we have a question about what we could do if an employee refuses to wear a mask when in the office. We're going to have an interactive exchange with that individual. We're going to have to say, you know, our standard is that you wear a mask. Why are you refusing to wear a mask? If they say they have a health condition or asthma, then we're going to have to determine whether it's a reasonable accommodation to allow that person in the work environment without a mask. In a lot of situations, the answer is going to be no. That right now we have a direct threat. We don't know all the ways in which COVID-19 spreads, but we do know that the mask wearing will assist in the spread. And one of the essential functions of the position is, you know, to wear the mask safely when you're in contact with other individuals. Unless we can move that person into a space in which they will have no contact with any third parties, you know, it's going to be a fact-specific inquiry in all matters. But there's no problem with having a reentry policy or reopening policy that requires everyone to wear masks at all times.
Right, and I think in terms of the direct threat, that also applies to things like temperature taking too as well, correct?
Correct. So if someone says, I refuse to have my temperature taken, we're going to say, well, why? If they say it's a violation of my civil liberties, say, well, okay, then you're choosing not to work, then you're making a choice not to work here. But these are our policies and practices, unless you have a religious reason why it's in violation, a health reason why it's in violation, or some other protected category, then you need to comply with the standards or the steps we're taking to protect other employees and the public.
And we're seeing some questions too about questionnaires and things like that. So depending where your business is or what states or locales you're in, there are some that are requiring a checklist or an affirmation by employees before the start of each shift. Others, it's more of that recommended or best practice, but certainly a good idea. And in terms of HR best practices, either having that on a document that's done prior to starting the shift, or I've heard of some technologies, time and attendance and things like that, where it's kind of been built in as part of the signing in procedure.
Absolutely. And we have a great question that says, if state guidelines say that 60 plus shouldn't come back to work, there's no risk for age discrimination. The answer is no. One of the biggest issues and problems that we're seeing right now is different agencies not communicating with other agencies. So we have the CDC saying that it's inappropriate for employers to ask for a doctor's note if an employee says that they are sick or has COVID-19 symptoms. The problem with that guidance is if you don't get a doctor's note, you can't certify for any form of FMLA. It's difficult to begin the ADA interactive process, and you potentially are limited in your PPP reimbursement under the Department of Labor and the IRS provisions. You're potentially limited under the Families First Coronavirus Response Act, based off of kind of IRS and Department of Labor regulations that require that you document that the need for leave fits within one of the 6 parameters set forth in the Families First Coronavirus Response Act. So each agency is operating in its own bubble, which is fine, except for it makes it that much more difficult for employers to operate, because they have to be mindful of all the different benefits to employees. So just because the state order says over 60 should not be returning to work, you still have to allow your employees to make that determination for themselves.
And on the other hand, in a response to a question that just came in, if employees are self-certifying that they're okay, but they're being observed as being symptomatic, that gives a little discretion to the employers, correct?
Absolutely, absolutely. So if you see someone who's coming in and they're coughing all over the place and they're saying that they don't have a cough, you need to sit down and have that discussion and say you can't be here as you're coughing all over things, or that type of using common sense while we're simultaneously trying to adapt new policies and practices.
Sure. So I am seeing some questions about, are certain things like temperature taking required or recommended? You really, it can vary state by state, city by city, and industry by industry. In some cases, some states have more detailed guidelines where the requirements differ depending on what sector of work you're in.
Absolutely. And I would direct people to Verrill's blog, Taking Care of HR Business. We have a full blog post that's a couple pages long that sets forth the pros and cons of temperature checking, the risks that are associated with it and the benefits of it. I would remind people that, that having a temperature in and of itself is not going to tell us whether the person has COVID. They might not have a temperature and do have COVID, or they might have a temperature but not have COVID-19. So just be mindful of that.
Great point. Okay. All right. So we talked a fair amount about FFCRA and things like that. Let's talk about the interaction between some of our longstanding and well-known leave statutes and how those are applied to this new environment and new pandemic.
Yeah, and I think you said it perfectly, Paul, is that all of these statutes are still applicable. So yes, we have this whole host of new rules and regulations, but we can't lose sight of the fact that all the statutes that previously were in effect are still in effect. So if you have over 50 employees within a 75-mile radius, the FMLA was still applicable to your employees who had worked for you for over a year and worked over 1,250 hours. So if you garner information that the individual has COVID-19, that is going to qualify as a serious health condition, and you're going to want to provide FMLA paperwork. Granted, they're taking Families First Coronavirus Response Act paid leave, but the FMLA time is going to start running kind of immediately once they go out on leave. So making sure that you're providing all the protections the individual is entitled to is really important. Similar when they're, when they're ready to return to work, having that ADA reasonable accommodation dialogue. So even though people are focusing in on Families First Coronavirus Response Act and the state, federal, and local reopening requirements or standards, remember that when someone says my anxiety is really creeping up and I'm having difficulties, or I have asthma, that all of those things could trigger your duties under federal FMLA, state FMLA, and then local or state paid sick leave laws.
Yeah, great point. So again, similar to FFCRA, it's just really crucial that anyone serving as an agent of the company, meaning supervisors, managers, what have you, especially if you're not always present, and the size and scope of your business, that it's a great time to do some retraining, especially if business is down and you're looking to use those PPP funds and fill some hours with useful time. Now's a really great time to get back to the basics of training on some of these concepts. So FMLA is a great one. So many managers and supervisors that we speak with and work with aren't really aware of what FMLA entails and what the responsibility and expectations are of businesses and of managers and supervisors when it comes to recognizing potential FMLA situations and how much onus is really on them to identify those situations. So if you haven't invested already in training, I think right now is a great time to do so. All right, so let's talk about a little bit, for those businesses who haven't been able to bounce back and haven't been as fortunate and have had to do some large scale layoffs. And while that's devastating enough, that devastation can be compounded when it comes to not following all the necessary procedures and dotting your I's and crossing your T's when it comes to doing those mass layoffs.
Absolutely. So there's a multitude of things to be mindful of, but mass layoffs really trigger requirements under what's known as the WARN Act, or the Worker Adjustment and Retraining Notification Act. And the purpose of that act is to provide employees with notice of the fact that their employer is either going to have a covered plant closing or a covered mass layoff. The WARN Act only applies to really kind of larger employers. So if the employer has 100 or more employees, excluding part-time employees, or they have 100 or more employees, including part-time employees, if those employees all collectively work at least 4,000 hours each week, excluding overtime. Now, that was a mouthful, and the thing is if you are looking at mass layoffs, you need to contact counsel to determine whether or not you have obligations. At the beginning of COVID-19, mid-March, there was a number of arguments that were made by employers that they couldn't give appropriate notice because of the pandemic and what happened. That argument is not going to hold water if you are laying people off or terminating people or shutting down plants at this point in time. So just be mindful that you might have obligations there. And then also, a lot of states have what's known as a mini WARN Act, which may not include notice, but it might include severance payment requirements. So just be mindful that these standards and statutes exist. And I don't want to get into a ton of detail about it because we are running short on time, but just knowing that these statutes exist is really important.
Yeah, no, excellent points there. All right, so aside from full or partial business closures or mass layoffs, let's take a little bit of time to talk about both the legal and HR ramifications and considerations when doing any type of layoffs, even if it's just for one person or smaller than what would qualify for WARN or mini WARN.
Yeah, so layoffs generally, we're going to want to come up with a process in which we can return and explain why certain people were chosen for layoff. So look at each sector of your work environment and say, what are our needs right now? What are our expected needs in the next month, 3 months, 6 months, kind of do that analysis. And then look at people who maybe have transferable skills. These are individuals who have this skill set or don't have this skill set who can perform the tasks that we're looking for. Oftentimes employers, when they are faced with having to make cuts, are going to say, well, this person is a pain in my rear, so let's get rid of them. People who are pains oftentimes are pains because they're complainers, and oftentimes people who complain about things qualify as whistleblowers, because while they may complain about the heat in the office, while they may complain about the way in which the office is set up, they also likely are complaining about things that potentially could be viewed as violations of the law, whether it's understaffing in a hospital or a healthcare setting, or it's different accounting functions, those type of things. So be mindful that when you're choosing kind of who is part of a reduction, that you're doing so in a non-discriminatory manner. Additionally, be mindful of any contract provisions which may be in place if the individual is not an at-will employee. So oftentimes contract provisions will include terms that say if it's a termination not for cause, that we're going to continue to pay salary or benefits for X, Y, and Z period of time. If the purpose of the reduction is to decrease expenses or decrease payroll costs, choosing people to terminate but then having to continue to pay them under a contract may not accomplish kind of what you're looking to do. Additionally, be mindful of the language that you use. Furlough is a term that we rarely use other than in the construction industry. And even in the construction industry, there is a lot of use of the term layoff when the employee would still remain employed with the employer, but they didn't have any work available for some type of seasonal issue or something along those lines. Furlough would be something that you do for employees who are going to maintain and continue to be employed by you, but you simply don't have work for them at the time. And then laying someone off is going to be, you no longer work for us. We don't expect to have work for you in the future. But when you're communicating those things with employees, just make sure you're clear about what your words and terminology mean so that they know what to expect moving forward.
Yeah, that's just so crucial, you know, whether it be the furlough versus the layoff, or a termination for cause too. So, I mean, at all times, I think businesses will like to lean on that layoff term to kind of break things off more easily, but there's a lot of potential ramifications. So, you know, I would recommend against using the term layoff if that isn't what it is. If you're laying someone off and then rehiring for that same position, you know, right there then after, you got to figure that person that you're laying off and telling them that the position's been eliminated or the department's being eliminated or what have you, they're going to be searching the job boards looking for their next opportunity. And if they see their job they were just laid off from listed there, that could potentially be trouble. So And in addition, when we talk about PPP application, one of the additional allowances for reducing your FTE number in your comparison calculation is termination for cause. So something like a layoff wouldn't allow you to remove that person, but if you can prove and document that you terminated someone for cause, that does allow you to remove that person from the FTE calculation. So a lot of considerations there. Just be very mindful, as Tawney said, the terminology you're using, whether it's a furlough, a layoff, or another type of termination. All right, and let's round things up with OSHA. So OSHA's put out quite a bit of communication and a guide, and separated things out by kind of what level risk different businesses might be, and what the expectations are for each of those kind of levels of risk. Well, what do you care to add to kind of the OSHA aspect to litigation and exposure for businesses?
Yeah, so generally just be mindful of the general duty requirements. If you're not somebody who previously had OSHA record keeping duties and obligations, you should go to the OSHA website at least and find out information that may have evolved or be applicable to you as a result of COVID-19, because there has been an evolution in the guidance. Additionally, if you are bringing in chemical cleaning agents to increase the amount or type of cleaning that you're doing to decrease the spread, make sure you're reading all the labels and you're taking all the precautions set forth there. Normally, we would only have a handful of employees who are touching or using cleaning agents. We're now moving to a time in which likely all employees are going to be using a form of cleaning agent. So make sure that all precautions in the use of these hazardous substances are being followed, and double check on the OSHA website to see if the use of different chemicals will result in you having obligations from a reporting standard or some type of record keeping requirements. Additionally, training is so very important. As you introduce different cleaning solvents or different practices, social distancing or other practices in reopening, if your employees aren't trained, then those policies or practices have absolutely no meaning. So performing trainings, making sure that you are recording and documenting those trainings is really, really important.
Yeah, no, great point. I believe OSHA did just, as businesses are kind of moving from one phase to another, and there are more applicable businesses moving to that reopening stage, I do believe within the last week or so, OSHA has updated their guidelines. So if you're going off of some of the guidance early on during the pandemic, just double check and take a look at revisions and updates that OSHA may have provided in the last week or so. All right. And whistleblower. So I know you've shared quite a bit of really valuable information about when employees, based on their actions and things that they're saying or doing, could qualify them as whistleblower statuses. Could you elaborate that in a little bit more detail?
Absolutely. So OSHA has whistleblower protection. So there's OSHA anti-retaliation provisions that state that if an employee makes a complaint regarding perceived unsafe work environment, that they are protected against retaliation. So in the current situation, what we're seeing a lot more of is people who are claiming that the work environment isn't safe or additional precautions need to be taken, and then who are bringing OSHA retaliation claims. So be mindful that when people start verbally complaining about these things, that it quickly moves them into a protected class. Additionally, you should be mindful and understand your state whistleblower protection statutes that are in place, which also could provide information about, let's say somebody says, I don't think that so-and-so should be working for X, Y, and Z reason. If it's because of a protected class or it's because of a safety precaution we're not taking, all of those complaints, if they're regarding a real or perceived either violation of a law or policy, could place that individual in a protected class, and we will start to see whistleblower statutes, whistleblower claims. The firm, I mean, just in the last week, we've seen at least 2 filings with clients making these type of allegations. So just being mindful that people who are complaining about these things fall in a protected class.
Yeah, yeah. I mean, I think we just all have to understand and realize that tensions are very high. People are stressed out. There's a lot of changes going on in people's professional and personal lives. So I think both from the employee perspective, when employees might say something out of line or be a little bit short, as well as us as business owners and managers and supervisors and decision makers, you know, we're feeling it as well. So it's just always prudent to not act reactively when things happen. When you see maybe a social media post about something, or an employee has a comment, or you hear about something, to kind of gather all your facts. Certainly consult with your HR team, with legal counsel as appropriate, before getting yourself into deep trouble and litigation. All right, and lastly, let's, I know we're running up on time, but let's quickly touch on wage and hour, because this may be one of the most impactful, or where we might even see the most amount of action in terms of legal activity.
Absolutely. So for your employees who are working from home or telecommuting, you want to make sure that you have a policy in place that sets forth that they are, you know, what hours they're working, having them certify the fact, especially if they're non-exempt, that they're only working kind of their normal schedule. If they are working more than their normal schedule, making sure that you are paying them for all hours worked and all hours over 40 at an overtime rate. Or if you're in a state such as California that has additional requirements versus based off of the day of the week worked, or how many hours in a certain day, be mindful of overtime provisions there. But having and updating your work from home policies and making sure that all your employees understand your expectations is really important. Paying individuals for time that they take outside of work, either to test and to take their temperature or to respond to questionnaires before they return to work, you likely want to consider adding maybe 5 minutes to each person's day that's compensable time as they take their temperature at home or as they respond to questions on an app. Have individuals kind of test how long it takes to respond to those questions. And for your non-exempt employees, you're likely going to want to consider paying them. That is likely the least risky. Paying them for that time decreases the risk the most. A lot of people would argue with me that the time spent on the testing or answering the questions is de minimis, but I don't think that anyone wants to be the test case as to a wage and hour lawsuit on that. Additional time that employees may need to, it's called donning or duffing, so putting on and taking off personal protective equipment. You're going to want to be likely paying employees for that. So if employees now have to arrive an extra 15 minutes early to put on a whole host of different forms of personal protective equipment, that's something that you're going to want to pay them for, so that'll be compensable time.
Yeah, no, I think you brought up a lot of great points there, especially about the work from home and the telecommuting by the non-exempts. I mean, that's been a growing challenge as the workforce in general has become more virtual and more home-based, but it's certainly amplified now. So it's just really important that as you said, you've got policies in place and expectations both for productivity and working time, and making sure that you're getting an accurate snapshot, because whether you authorize it or not, if they're working, that's on you. You're permitting them to do the work, so you're responsible for that time worked. All right, so that brings us to the end. I know we're running up on time. We did our best. I thought it'd be a little different to try to answer questions live on each topic as we went through them. I don't know if there are any closing thoughts or comments that you have before I hand it over back to Jackie, Tawney, or a question that you see that you feel deserves addressing right now, or just kind of an overall closing remark?
So I thank you, everyone. I apologize if I did not get to your question. I do see that there were a lot of people asking for a copy of the proposed language that I would suggest using, not in a waiver format, because it's not a waiver, but more of a general acknowledgement. If you shoot me an email, I'm happy to provide you with the general acknowledgement language that I would propose free of charge. So just understand and recognize that no legal relationship would be created, no client-attorney relationship, but I can give you that language and you can go from there.
Excellent. That's awesome. Thank you so much. All right. So with that, I'll hand things back over to Jackie.
Awesome. Thank you so much, Paul. And thank you, Tawney, also for presenting today. We want to thank all of you again for attending this webinar. I want to quickly remind everyone that a link to the recording will be sent out within the next couple of hours, also with these slides. We also want to make you aware that MP is offering a free HR consultation to all webinar registrants, including a consultation on critical HR topics, including PTO tracking, interacting with unemployment, families first, and anything else you might need to know to stay compliant with new legislation and regulations. The second thing is a CARES Act advice and guidance on accessing the resources you need. And third, a complimentary invoice review of your current HR and payroll provider. If you have any further questions, please send them to marketing@masspay.net. Thank you so much again for being here today, and we hope that you stay healthy and have a great day. Thank you.
Thank you so much, everyone. See you next week.